Now, in the same line, I'm go with a related topic. I'm going to give the floor to my colleague, Professor Bogdan Iancu. So, Bogdan Iancu is a professor at the University of Bucharest, Faculty of Political Science. He teaches there EU institutional law, European constitutional law, introduction to the into fundamental of public international law, and international human rights, including the convention. Professor Iancu was educated mainly in Iași, but also at the Central European University, where he was a student of our former colleague Professor Andra Shayo, and he wrote. A lot in different topics of constitutional law, constitutionalism in general, and had several research projects and research visits in different countries, like Heidelberg Institute in Max Planck Institute in Heidelberg, McGill University, and others. And Bogdan will address the question of state of emergency, COVID-19, and the limits of legal dogmatics. So I'm looking forward for your presentation, Bogdan.
You're muted.
No? Can you hear me now? You should be able to hear me now, I think. So I was just thanking Julia for characteristically warm and very generous introduction. Obviously, it can only go downhill from here. So, but since she mentioned Andra Shayo, and I'm also happy that she asked me to speak about the state of emergency, because my presentation will complete the presentation of my dear friend and colleague, Cosmin Cercel. And I will begin to close the circle with a reference to my former dissertation advisor and former colleague of Julia, Andra Shayo, who in a book on constitutionalism co-written with Renata Uitz described international, transnational constitutionalism with the formula referring not to international constitutionalism, sorry, there was a, can you see me now? That's very unfortunate.
No, we see and hear you well.
You see and hear me well, but I cannot see you because, yeah, now I can.
No, it's fine. Okay.
So Andra Shayo mentions the literature, not international constitutionalism as such, but the literature, the treatment of international transnational constitutionalism using the formulation duckbill constitutionalism. Duckbill constitutionalism. What does he mean by that? Namely, that when you have something completely new that challenges your received knowledge of reality, you usually resort to surface similarities. Also, and this is what happened when the English discovered Australia. They discovered the platypus, and the platypus was something completely new. They sent a pelt to London, and the naturalists in London didn't know what to make of it. They called it a duckbill because it has a beak that resembles the bill of a duck. And naturalism, the Royal Museum, they tried to look for stitches to see if that wasn't a beaver upon which a duckbill had been stitched. And they called it a duckbill. It was a platypus. It was something completely new. They didn't know what to make of it. Obviously, just like Shayo didn't try to ironize transnational constitutionalism, I don't mean this as a derision of the gravity of the crisis, because people died, businesses went bankrupt, our lives were turned upside down. So obviously this is a crisis, and it is a crisis the likes of which we have never seen. Now, however, it is a new kind of crisis. It is a different sort of emergency, and we deal with it using the instruments and describing it with the vocabulary that we inherited from the past. Yet it is new. Now, one thing that we know about emergencies, about states of emergency, one main thing is that they are suspensions of regular illegality during which the executive is entrusted with prerogative powers to deal with the contingency. And then the situation reverts to normality. Romans were, and whatever fetters there are, they're primarily procedural. You can see that from the Roman times. The dictator had 24 lictors. There was no intercession. There was no collegiality. He only appointed a substitute dictator, the magister equitum. We know that he had more lictors than the consuls, that they were empowered to bear battle axes also within the city walls, and that he had absolute imperium. And during this period of dictatorship that took precisely 6 months and not a day longer, or until the emergency was dealt with. And the reason why it took 6 months is that they could get a grasp of the reality. They only fought in the summer. No, they didn't fight in the spring. They didn't fight in the late autumn. They only fought in the summer. So they both controlled the conditions of the emergency and the reality to a certain extent to which emergency applied. And this is the way in which modern constitutionalism deals with emergencies up to nowadays. No, the English with characteristic pragmatic spirit, they didn't even have a legalization of the state of emergency. The executive simply did whatever the executive thought was necessary to do, but at the prime minister's risk, meaning that Parliament could indemnify, could adopt a bill of indemnity later on or not, and then the executive would be impeached. The chief executive would be impeached. And this is the kind of regulation that we have used. But the pandemic challenged this somewhat, and I will use only a Romanian example, but perhaps, obviously, I don't have the time to make comparisons. This is an intuition, the beginning of an intuition. Namely, we used the instruments that we had to deal with emergency, namely Article 93, in the Romanian constitution, state of siege, state of emergency can be declared on the basis of a presidential decree for 30 days. If Parliament is not in session, it is convened within 48 hours. The Parliament has to be asked for authorization of the presidential decree within a period of 5 days. And of course, the article is schematic. So Ordinance 1 per 1999 fleshed out the particular conditions in a specific historic context with reference to a characteristically recognizable emergency, namely the coal miners' assault on Bucharest in the late 90s. And it is obsolete. It was revisited very shortly, but it is obsolete. Constitutional Court didn't review it completely. For example, the ordinance mentions an instrument that doesn't correspond to the ethos of the Constitution as amended, military ordinances. And that comes from the time when the Ministry of Internal Affairs was semi-militarized. Obviously, we had to give that up as a condition of joining NATO and the European Union. So the very terminology military ordinance that's adopted by a civilian minister, the Minister of Internal Affairs, does not correspond to the spirit of our times. And we also used a quasi-emergency instrument, namely the state of alert, that we regulated also in the wake of an actual classical emergency, namely the post-Madrid terror attacks. And as a NATO member, we adopted the Emergency Governmental Ordinance 21 per 2004, which was supposed to be preceding the gravest form, namely the constitutional state of emergency, a lighter, a quasi-emergency form, but regulated in mutatis mutandis symmetric way, namely not the president declares by a presidential decree, but the prime minister by a governmental decision. Now, and what you can note is that the more at the beginning, of course, we treated the sanitary crisis as an emergency. We activated also Article 15, one of the few countries of the Council of Europe who did that. Hastily, I might add, at the beginning of the state of emergency, wisdom counseled that there was no need to do it because the European Court of Human Rights has the wisdom of second-guessing governments when they activate derogations on Article 15, but we did it anyway. So we militarized and gave an executive push to the whole deal. Yet the more time passed, the more it was clearer that the instruments that we used were not well adapted to the situation. So what began as treating the sanitary crisis as an emergency situation ended up with a law that treats it as a sanitary crisis with certain hybrid emergency forms. The Constitutional Court also helped because decisions on the older emergency governmental ordinances realigned the relationship between the branches. But at any rate, what actually happened, so the situation that we have on hand, does not confirm what Schmittian analysis, Clinton, Rossiter, constitutional dictatorship, power of the executive power at the expense of the parliament, told us. No? So it's a new kind of situation that to a certain extent we haven't wrapped yet our collective heads around. That's pretty much all I had to say. And if there would be questions, I'll gladly address them in the question time. Thank you.
Thank you very much, Professor Iancu. I think that your intervention was very much in the continuation of the intervention of Professor Cercel. And it was the other side of the coin, indeed. Not only that we can see emergency in a lot of places, embodied emergency, but also, as you said, we don't have yet, and what I try to expose, we don't have yet a theory that is able to cover what we have nowadays. And we have different situations, and maybe is too early for a theory. Normally, they come afterwards. Maybe for a theory, we need more substance of what will happen in several emergency situations during the pandemic, because the pandemic, as we all know, is not ready yet. And which development will be, or maybe simply that indeed we are not in the situation that was described by none of these classical theorists of the state of emergency, at least for me as well. So it is not only about how we revisit in the convention. We revisit in the convention the rights in the view of the COVID-19, but it also how we are going to revision the theory of emergency in order to apply to concrete cases, but also in order to have this extremely important theory of emergency. And I think that the beginning of this dilemma is only the fact that Schmidt himself, he was a normative theory, so he was thinking to a certain concrete situation. So this is his relationship with the reality was so strong that even if, of course, he's a very, we know him very well, but it was difficult for him to theorize. And afterwards, what happened? It's in the same time with the others, the main theories that were preoccupied by different parts.